Welcome back to the next session, that is CA Intercorporate Law in all the sections revision we started in my earlier class. If in case you did not watch, or if you are very selective that certain sections you know very well, it's okay. You can skip those sections and watch the other sections. But I request all the students who are taking exam in the month of May 2026, corporate law. In group one, if you are very careful about corporate law, it will be scoring, and this will help you to push your aggregate because accounts is very bulky. Though it is interesting, accounts is very bulky. So one small mistake will cost you very dearly. And taxation, as you all know, it's very bulky. So therefore, the only subject in group one that can help you, that can push your score to aggregate plus, that is 60 marks plus, is corporate law. More revision, more understanding, better understanding, and more practice in writing that will help you 100% to score better marks in this subject. Let's continue from earlier class, that is section 12. Section 12, Company Law 2013. Section 12 talks about registered office of the company. That means first very important thing is every company should have registered office within 30 days from the date of incorporation. What is the proof that you have registered office within 30 days? So you have to file INC. You have to file INC 22. You have to file ILC 22. INC 22 is filed by company with ROC stating that office is ready for all the correspondence and communication. Is my point clear? And one very important thing is, if in case you want to shift office from ROC to ROC, you need to pass special resolution. So section 12 talks about shifting the office. So when it comes to shifting office, so there are basically you need to think about four very important things, right? Sometimes you want to shift office within the city. Sometimes you want to shift office between ROC to ROC, but the state is same. Sometimes you want to shift what do you call within the state, city to city, city to city. ROC is same. This is within the city. Okay, sometimes you want to move from state to state. Actually, registered office is basically the concept of memorandum, right? It's one of the clause in memorandum. And if you want to shift a registered office, there are four very important things within the city. Say, for example, you're in Bangalore, you want to move within the city. So obviously, nothing is required. Board of directors can take a decision. Alteration of memorandum also is not required. But when you move from city to city, where ROC is same, state is same. ROC is same and state is also same. In such case, definitely board resolution is very important, and you're moving from city to city within the same state. Special resolution is also very important. So that means within the city, you don't need shareholders' permission. City to city, you need shareholders' permission. But now the question comes, in India, Maharashtra has two ROCs, Tamil Nadu has two ROCs. Rest all states have only one ROC. So what happens? Suppose in Karnataka, there is only one ROC. If you want to move from one city to another city, like let's say Bangalore to Mysore, you want to shift. ROC is same. ROC is same. City to city, ROC is same. Bangalore to Mysore, ROC is same. State is also same. So you pass board resolution, you pass even special resolution, you pass even special resolution. Got my point? But when it comes to Maharashtra and Tamil Nadu, where there are two ROCs, if you're moving from ROC to ROC, but state is same. You are moving from ROC to ROC, but state is same. Since you are changing the ROC, there is every possibility you will have to take the permission from regional director. So ROC, if you are moving, you need a permission from regional director. So board resolution, special resolution, regional director permission. And if you're moving from state to state, then you need central government permission. Those central government powers are delegated to RD, regional director. So this section 12 clearly indicates if you want to move from state to state, you need to take a prior approval, prior permission from central government. That prior approval permission on behalf of central government is actually delegated to regional director. And if you want to move from ROC to ROC, states like Maharashtra and Tamil Nadu, where there are two ROCs, you need regional director permission. That is exactly what is it called? Section 12. Read that if you want. Section 12. Got my point? So it's basically shifting office. And moreover, Section 12 is related to registered office in particular, but Section 13 also talks about alteration of memorandum, passing special resolution. This information will be there in Section 13 also. Let's see now what is Section 13. Section 13 clearly talks about changing or altering memorandum of association clauses. Changing or altering memorandum of association clauses. Excuse me. Changing or altering memorandum of association clauses. You have got name clause, right? You have got name clause, you have got objective clause, you have got liability clause, you have got registered office clause, which is also dealt in Section 12. You have got capital clause. So whenever you want to change these clauses, you will have to pass special resolution. But when it comes to name change, you will have to take even central government permission. And when you want to move office from state to state, as we studied in Section 12, you need even central government permission. So there are certain clauses in memorandum. If you want to change, you need central government permission. The first clause is, if you want to change the name, apart from special resolution, you have to take permission from central government. And if you want to shift office from one state to another state, apart from special resolution, you also have to take the permission from central government. So Section 13 is an elaborate section which talks about all the clauses change. In the textbook, very clearly, summary is given. You just go through it. Let's see now what is Section 14. Section 14 talks about alteration of articles. As I told you in my earlier class, articles talk about rules and regulation. It is about internal management. It is about internal management of the company. So when you want to change articles, when you want to change articles, understood, when you want to change articles, you will have to pass special resolution. You will have to pass what? Special resolution. And there are some situations where you may have to take central government permission when you alter articles. What is that situation? The situation is very simple. Generally articles change will come the moment when the nature of the company changes. I repeat, articles alteration will come into existence the moment you change the nature of the company. Say, for example, you want to move from private company to public company. Under Section 18, we talk about conversion of companies. And if you want to convert private company to public company, you will have to remove the restrictions because a private company is becoming public company. When it comes to public company converting into private company, as long as you're a public company, there are no restrictions on transfer of shares. If you want to convert public company to private company, you will have to remove restrictions. Therefore, conversion of public company to private company, wherein you will add restrictions, because you're trying to become private company, then you need central government permission. And conversion of companies is also given in Section 18. All right. I'll also show you end of these sessions. I will also solve latest question paper. Clues I'll give you how to solve everything. We'll read the question paper properly related to certain sections where section has to be utilized. That also I'll guide you. Just spare some 20-30 minutes time every day until this 1 week, 10 days, and make sure you have a clarity on these sections. Section 15 talks about alteration of MOU and alteration of ACE should be updated. Whenever you happen to alter memorandum of association and articles of association, the changes that were made in memorandum and articles of association is supposed to be updated in all the documents wherever you have given those documents. There is a possibility you must have given this document to ROC. There is a possibility you must have given these documents to banks. There is a possibility you must have given these documents to clients where you had an agreement or contract, etc. Wherever these documents were earlier given, these documents are supposed to be updated in all the documents when you altered memorandum and articles. That is Section 15. So if you see carefully, Section 4 is about memorandum. Section 5 is about articles of association. Section 6 talks about act overrides articles in memorandum. Section 7 talks about documents to be submitted at the time of incorporation. Section 8 talks about non-profit company. Section 9 talks about effect of registration of the company. Section 10 talks about effect of registration of memorandum and articles. Section 10A talks about commencement of the business. Section 11 is deleted. Section 12 talks about shifting of office from one state to another state. Section 13 talks about alteration of memorandum by passing special resolution, and Section 14 talks about alteration of articles. In one case, you have to take the central government permission. That is, if you wish to convert public company to private company. In your articles, you may have to add restrictions. Those restrictions, when you want to add, you have to take permission from central government. And section 15 says whatever alterations that were updated in articles and memorandum, they are supposed to be updated. They're supposed to be updated in all the old documents wherever you gave it. All right. Yes, it's a revision class. It's not a regular class. So the students who are attending for the first time, other than brick students, please understand. In brick students, though, I normally make sure that all the sections they remember, and in fact, they remember most of them. But some students, if in case you still want to have some clarity, you please do that and share this video with all the students who are preparing for this one, CA Intermediate. And don't forget to subscribe. Okay, that is very important. When academic information is given, you need to encourage people. Okay, that is very important. Section 16 talks about rectification of name of the company. When company name is identical, so section 16 says like this: if your company has been incorporated, but later on somebody came to know that your company is resembling their name, your company name is identical with their name, your company name is identical with the existing company, resembling or identical with the existing company, existing LLP or existing trademark. Trademark is the name of the product. Trademark is basically what? Name of the product. So if existing, your company name is matching with existing company, your company name is resembling, not exactly the same, but resembling, and your company name is matching with trademark that is already there in the market, and such people usually will complain to central government. Then in such case, section 16 clearly says central government would ask company to change name within 3 months by passing ordinary resolution. The resolution is very important here. Normally, if you want to, just now above in section 13 memorandum, one of the clauses name clause, if you want to change anything in memorandum, I clearly said you have to pass special resolution, and name clause is a memorandum clause. But now why are we saying this is an ordinary resolution you have to pass to change the name? Because you're not changing the name voluntarily on your own. You are changing the name on the instruction of the central government. Therefore, you need to pass only ordinary resolution. You don't have to pass special resolution when the central government had asked you to change the name within 3 months, because your name is resembling, your name is identical with the existing company or a trademark. That is the point. All right. Awesome here. So I hope you're learning something 100%. It definitely helps you to to have a grip on all the concepts. Especially I'm telling you, these sections classes will 100% help you to answer those MCQ questions at ease. Your our aim is answer 30 on 30 and another 30 finish from the descriptive. Easily you can score. Yes. And you will thank me afterwards for that. 100%. All right. Next. So this is done. Next, section 18 talks about conversion of company. So private company can be converted into public company. No need of central government permission. Public company is converted into private company. Need of central government is very important, because when you convert company, there are changes in articles of association. The next very important thing is one person company cannot be converted into section 8 company, and section 8 company also cannot be converted into one person company, and one person company cannot be converted into non-banking finance company. So section 18 talks about conversion procedure. Any conversion usually happens with the board meeting, special resolution of the shareholders, so on and so forth. That is one non-significant section. I don't think so you will have a question on this. But remember, we don't know, because I told you my objective is to give you 30 on 30. And after this, I also told you very clearly, few case law questions will solve and MCQs also will solve. Okay, some previous MCQs will take and solve. That will help you a better understanding. So let's quickly close this. Section 19. Section 19 talks about subsidiary company cannot hold shares in holding company. So we have a holding company and we have a subsidiary company. So holding company is a company which holds 51% of voting power, 51% of paid up capital, and 51% of the directors in this company. So what is subsidiary company? This is section 2, clause 87. If you remember, this is section 2, clause 46. So what is subsidiary company? The company whose 51% of voting power, 51% of paid up capital, 51% of directors are in the hands of other company. That other company is called holding company. So that means common sense you apply. It is the holding company which has capital in subsidiary company that is more than 50%. That is at least 51%. I repeat, it is a holding company which has capital in subsidiary company. So common sense you apply. How is it possible? How is it possible for a subsidiary company to hold shares in holding company? It's like Papa has given money and again you are lending money to Papa. That is a comedy scene actually, right? But there is a situation sometimes there can be a situation where beta can hold the shares of the Papa. So that means section 19 clearly says beta subsidiary company cannot hold shares in holding company, but under three circumstances, subsidiary company can continue holding shares in holding company. Have a proper headphones, proper infrastructure, then you will enjoy these classes. And do not worry, I already so there might be some misunderstanding in the section that you had already studied. Such misunderstandings can be easily recovered now in the revision, right? Just while you are studying for exams, in the break time, just watch it. That's it. Because it will help you because somebody is talking to you, somebody is telling you. You're not reading, you're not making any effort, right? So subsidiary section 19 says subsidiary company cannot hold shares in holding company since holding company only holds shares in subsidiary company. But under three circumstances, subsidiary company can hold shares in holding company. Under three circumstances, subsidiary company can hold shares in which company? Holding company. Number one, if it was already holding shares. Number two, as a legal representative, there is a possibility one of the shareholder of holding company must have kept subsidiary company as a legal representative. That means subsidiary company, if it was already holding shares before it even became a subsidiary company, it can continue holding shares. As a legal representative, it can hold shares. Understood? As a trustee, it can hold shares. Trustee is basically an entity with whom the company has kept shares for different purposes. You will study in advanced syllabus of these concepts. So section 19 is very simple. Subsidiary company cannot hold shares in holding company. However, subsidiary company can continue holding shares under the following three circumstances. Number one, if it was already holding shares, it can continue holding shares. Number two, as a legal representative, it can continue holding shares. As a trustee for the shares of holding company, it can continue holding shares. Quickly move on. Section 20. What is Section 20? Section 20 talks about service of documents. Section 20 talks about service of documents. Common sense you apply. Common sense you apply. I want, because how do you serve documents? I will serve documents by post, by registered post, by speed post, by fax, by email, by any electronic mode, right? Yes or no? But one small. If a company wants to send letters, company can definitely use ordinary post as well. But if anybody wants to communicate or anybody wants to send any communication to company, they cannot use ordinary post. They will have to use either registered post or speed post or courier. That means indirectly, if someone wants to send any communication to company, there should be an acknowledgement of receipt of such communication. But when it comes to company has the option to send ordinary post also if it wants to. That is section 20, serving of documents. Awesome. Let's finish the next section, that is 21, authentication of documents and contract of agreements. So generally, company is an artificial person, right? So company keeps entering into any agreements, right? Like with the supplier, it will have an agreement with the banker, it will have agreement with an insurance company, it will have agreements. It will enter so many agreements and contracts during its day-to-day life. In the ordinary course of business, company keeps entering into many agreements with outsiders, right? So the question is, since company is an artificial person, so who actually authorized those documents? That is section 21. It says key managerial person will authorize those documents, or any authorized officer or any employee who has an authority. That means board of directors might authorize somebody. Otherwise, key managerial person. Key managerial person means what? Key managerial person means triple C, right? Triple C means company secretary, CEO, chief executive officer, and whole time director, manager, managing director. That means on behalf of company, whatever documents, whatever agreements, whatever contracts that are entered, they have to be authenticated by whom? They should be authenticated by KMP, that is company secretary or chief executive officer or chief financial officer or whole time director, manager, managing director. Otherwise, anybody authorized to sign. In the first lesson, we have got one more section called Section 22. I'm telling you, I'm cautioning all the students who are writing C enter. I'm telling you, do not ignore any section, because God knows one particular section which you have ignored, thinking that it is irrelevant, that might come for MCQ, or they might create a case law. So your job is to have a complete grip on the concept. And you go to exam like you have to win all the enemies who are standing there. That means every question is an enemy to you. You must be able to hand. You, if you choose selective, sometimes the enemy which is neglected is very danger for you, because you did not prepare to handle that enemy, right? So you know it, you heard about it, it was familiar to you, but you could not answer. The reason is you neglected. Negligence is very, very, very danger in CA exams. Be diligent in everything. Your job is to, so that's why some concepts will be boring. Yes, some concepts will be interesting. So you are not here to become CA just by reading only interesting topics. In future also, when you are in practice, some clients will be interesting, some works will be interesting, but some are not. But still, being a CA, you must take up every work which you have decided to take. Same thing you apply. Then execution of documents, in the sense, who will actually execution of documents, bills of exchange, promissory note, deeds, etc., etc. So they will, company will authorize a person, it says. Company will authorize a person, especially negotiable instruments, legal documents here. Above, section 21 talks about agreements and contracts. Section 21 talks about agreement and contract. Section 22 almost look like same, but here section 22 talks about negotiable instruments, mostly legal documents, deeds, lease deeds, rental deeds, promissory notes. So what company can do to sign this? Because every time board of directors or KMPs may not be available. Now what they can do, they can give a power of attorney. They can give a power of attorney to somebody. They can give it to one of the director also. They can give it to company secretary also. So what it says, with common seal. First of all, company is an artificial person. How company signs these documents? Company seal itself is the signature. Company seal itself is the signature. Is my point clear? If in case now you know one story, right? From 2015 onwards, company seal is not mandatory. If company seal is not used by company to authenticate these legal documents, then you can give a power of attorney to directors or company secretary. You understood? That means if you are using common seal, fine. If you're not using common seal, you have to authorize somebody. You have to give power of attorney. Means you have to transfer those rights to somebody. That is section 22. All right. Section 1, applicability. Section 2, definition. Section 3, formation of company. Section 4, contents of memorandum. Section 5, contents of articles of association. Section C, act overrides articles and memorandum. Section 7, documents to be submitted at the time of formation of company. Section 8 is non-profit company. Section 9 is effect of registration of the company. Section 10 is effect of registration of memorandum and articles. Section 10A is commencement of business. Section 11 is deleted. Section 12 is shifting of office from one state to another state. Section 13 is alteration of memorandum. Section 14 is alteration of articles of association. Section 15 is you have to update all the documents wherever you gave before after alteration of articles. Section 16 talks about changing the name if in case your name is matching or resembling with anybody. Section 17 talks about, section 17 I think we didn't discuss. We discussed. Section 17 talks about, we didn't discuss actually. Sorry, I forgot. Section 17 says these are to be given, that is memorandum articles, these documents to be given to members if they ask within 7 days. If in case anybody wants to copy, anybody wants a copy, you have to give them within 7 days, and you can charge up to 10 rupees or whichever is mentioned in the articles, whichever is less. So 17 talks about handing over the documents to members. Section 18 talks about conversion of company. Section 19 talks about subsidiary company cannot hold shares in a holding company, but under those three situations it can hold. Section 20 talks about service of documents, mode of serving documents. One clue in section 20 is company can use ordinary post also, but others who are serving documents to company cannot use ordinary post. Section 21 talks about authentication of agreements and contracts, KMPs. Section 22 talks about authentication of legal documents. Common seal, if not, power of attorney can be given to any one of the director or company secretary. That is the point. That is the point. So with this first lesson sections, we finished. See you in the next class for the next lesson sections. That is prospectus and this one. So please share this video to all the students who are genuinely writing, and this will definitely help you to crack better marks in MCQ. Have a good day. Take care.